be aware of?
In government plans, yes. The major issue in a government plan is the survivor benefit. In a defined benefit plan, most defined benefit plans that are sponsored by private employers, as long as the participant is not retired at the time, as long as the participant is still working for the employer, the plan will provide what's called a separate interest. That is, the actuary will actually go in and divide up the accrued benefit and provide a life annuity to the participant and a life annuity to the alternate payee. Government plans don't do that. Government plans provide what's called a shared benefit. That is, when the employee actually retires, the plan will pay a benefit to the participant, but it will actually pay two people. So it's one benefit, but the government will pay two people. If the participant at that time takes a life annuity, that life annuity terminates at the participant's death. So if the participant retires, takes 2 or 3 years worth of payments, and dies at that time, there's nothing left for the alternate payee. What you have to be careful of in that situation is to make sure that if you are dealing with a person who's in a government plan, Arizona State Retirement System, Federal Employees Retirement System are the two big ones, that you have some discussions about the survivor benefit being paid to the alternate payee after.
Let's talk a little bit about the mechanics here. What happens? Okay, the couples get they're divorced. They've divided up. They've decided in some way how they're going to divide up these pensions. How does that actually get divided? And what happens after it's, let's do that first. And then I want to talk a little bit about after it's divided, what happens and how they can collect.
Okay. When you've decided what you want to do with the pension, and I would actually like to be part of those discussions. I don't like to have things just come to me and say it's 50%.
My advice is always to clients is talk to Brian first to make sure, before we do any documentation, make sure it's okay.
I prepare something called a Qualified Domestic Relations Order. There's an old saw in tax law that says whenever you see the word qualified in the Internal Revenue Code, you know you have problems. and
as we talking about now, for the QDRO, for defined benefit plans?
Either one.
401ks also? Or
any sort of employer-sponsored plan, defined benefit plans, defined contribution plans of all stripes. You have to have what's called a Qualified Domestic Relations Order. It's defined both in the Internal Revenue Code and in the Employee Retirement Income Security Act.
So occasionally I've seen, I think, 401ks where they didn't need a QDRO.
Someone probably made an error there, probably at the plan level, but because if it is a 401k plan to pay the alternate payee something, they will need a Qualified Domestic Relations Order. The standards of some plans are very low. They'll often take the decree of dissolution and say, that looks fine to us, we'll pay out based on that, that decree. But I draft the Qualified Domestic Relations Order. My advice usually is to have that order ready to be signed by the judge at the same time you take the decree of dissolution. Though I'll admit that most of the cases that come to my office, the people are already divorced. There's already some language in the decree of dissolution.
I had a case where they did that. Saying I take the advice you did, and then they had to go back and reopen the judgment because they didn't even got the name. The names were incorrect.
Right. If I don't know what the name of the plan is, I can't draft an order, and I don't.
Or the clients will tell you this is the name of it, and it turns out that's not the name of it.
That happens all the time too. That's one reason why I like to get involved early, and I like to talk to the administrators at the plan before I draft an order and before the divorce is final. If you run into any snags, you try to get them taken care of before the divorce is final. So I draft an order. The Internal Revenue Code and ERISA both require that the plan only pay out to an alternate payee, to an ex-spouse, with a Qualified Domestic Relations Order. So I draft that order, and my advice is to have that order ready excuse me, at the same time that you take the decree of dissolution. You take the decree down, you take the order down to the judge at the same time. The judge signs both the QDRO and the decree of dissolution, and you get a certified copy of the QDRO from the clerk's office at the court. That comes back to me. I send it off to the administrator. If it's a defined contribution plan, most companies will take 6 to 8 weeks to review one. Federal Thrift Savings Plan might take 3 to 4 months. It does get quite a few of these things. It then contacts, or if it's doing things right, it will contact the alternate payee and say, you've been awarded X hundred or X $1,000 out of your former spouse's defined contribution plan, his 401k plan. What do you want to do with it? You can put it in your pocket. If you put it in your pocket, the plan pays it to you. It withholds 20%. It sends you a 1099.
Holds 20%
of the distribution to the...
Well, for tax purposes.
For tax purposes. Uncle always gets his cut. It is a taxable event. It withholds 20% for tax purposes. Sends out a check to the alternate payee, and then alternate payee can do with the funds as he or she pleases. You can roll it into an IRA, at which point then there's no tax at that time. And if it's rolled into an IRA, you can take it out at some later time and pay tax.
You say taxes. I just want to make sure we clarify, because it's I think important, is when these assets are moved around from the pensions, that's not a taxable event, is it?
No. The division is not a taxable event. If you are the alternate payee and you roll it from the plan to an IRA, that's not a taxable event. If the plan distributes it out to you, that is a taxable event.
That's something I've seen clients do also, where they will end up just getting a check from somebody,
right,
and then next thing they know, they're being taxed on it. It's important that it be rolled over.
Usually you want to have a direct rollover, which is you ask the plan to roll it into an IRA, which means you have to go out to some IRA custodian, usually a brokerage house or a bank, establish an IRA, get the routing information, give the routing information to the employer, and then have the employer send it directly to the IRA.
Let's go back to the defined benefit plan. Now, if you have a defined benefit plan, okay, and it splits it, and the money's not going over another plan, what happens? You have a husband and wife, it's vested, the plan's been split with a QDRO, and they both, it's like, how does that work in terms of...
Need to draw a distinction. Most private plans will provide that separate benefit and treat the alternate payee as a separate participant in the plan. Most defined benefit plans, and again, you're dealing with thousands and thousands of plans, each one of whom does it a little bit differently, but most of the defined benefit plans will then pay out the alternate payee in the annuity form, which is an annuity usually for your lifetime. If it is a government plan, you will not receive anything from the plan until the participant actually retires, and then you'll receive a portion of each payment being made to the participant. There are a couple defined benefit plans that will allow you to take out the money either in a lump sum or in installments over a period of time. There's one plan that I work with quite often that allows you to take it out over a period of 5 years. You can roll that into an IRA. But a lump sum or an installment distribution out of a defined benefit plan is unusual.
Let's say you have a spouse who is 62, husband is 62, wife is 50.
Okay.
Now he can start getting the benefits at 65. So at what point can the wife start getting the benefits? Can she get it? Does she have to wait till he's 65, or if he chooses not to collect them at 65, is she locked in at all? Or how much flexibility does the spouse have in that situation?
In a government plan, you do not receive anything until the participant actually retires. At least you receive nothing from the plan. There is a court case here in Arizona that says that if you're dealing with a government plan and the participant gets to an age where he can take normal retirement, and he doesn't at that time, you can take him back to court and have him pay you out of your own pocket the amount you would have received had he retired at normal retirement age. In most private plans that provide the separate interest where they treat the alternate